Welcome to the Legal Hour with Bailey and Galyen. I'm Keith Spencer, and I'm here today at the Legal Cafe at Main and First, where you can get some coffee and some advice from attorneys. And it's kind of a new thing we're offering here at Bailey and Galyen, and we hope you'll stop by and see us. Today, I'm with J.C. Bailey. J.C. Bailey's the Vice President of Bailey and Galyen. He's the head of the Probate Department and a good friend. I've known him for 20 years. Jay, welcome.
Thank you. Anytime Keith Spencer is going to interview me, I'm going to show up.
Well, Jay, probate covers a large area, but I don't think everybody's really necessarily aware of what all goes on. So what really is the nature of your practice and some of the unusual things you have to deal with?
Yeah. Probate is a broad area. The probate courts have pretty expansive jurisdiction. They may be handling guardianships, they may be probating wills, they may be engaged in the contest of a testamentary document, they may be called upon to try to interpret the meaning of a trust or some kind of a deposit agreement in a financial institution. So they've got pretty broad jurisdiction. It's almost impossible to practice in the entire area. One reason for that is there aren't enough hours in the day, but another reason for it is you probably don't have staff for it. The staff calling is pretty specific in the different areas where maybe you're working with doctors and mental health professionals primarily. In other instances, like we do, we draft a tremendous number of estate planning documents and then we probate a lot of wills, which sounds really, really scary because we've all been scared to death about probate. And so part of the misconception is I say we're more like veterinarians than medical doctors. And what I mean by that is a veterinarian knows that the same medication, the same treatment, the same skeletal structure, etc., for that animal is going to be markedly different than for another animal. And so each of our states has a jurisdiction, and they have rules with regard to how you pass real estate and how you do a will and how trusts are interpreted. And so in Texas, we have a probate system that is relatively straightforward and relatively simple if you prepare the documents in advance. If you don't, if you leave it up to, I'm sure it'll all work out, and everybody knows she's my wife. She's been my wife for 40 years, and everybody knows those are my kids. If you leave it up to chance, it's a probate system that can be extraordinarily complex and unfortunately time-consuming and expensive. What we do is we draft documents to avoid complexity and problems, and then we take families who have suffered a loss or in some instances have a loved one who's become disabled or incapacitated and help walk them through that process.
You've told me many times that writing a will is doing a really big favor to your heirs.
Indeed. And having it done by somebody who knows what they're doing, because some of it's counterintuitive. For instance, you would think that the more specific I got, the better my document would be. I'll give you an example. Dad passes away, and Dad's very meticulous, and he prepared his own will, and he put everything in order, and he even used the right terminology. He even talked about independent executors, and somehow he got a hold of a valid self-proving affidavit. So he did a lot of things well. He wanted to be specific, though. Instead of in his will saying that he wanted his daughter to receive any and all of his real estate, he put down the specific address and legal description of that house. So sure enough, had he not sold the house some 12 years before he died, bought another house, that real estate would have passed to his daughter. Instead, she's grieving. She shows me a death certificate and a will, and I ask her about the house, and she said, oh no, sold years ago. I said, okay, did he own real estate? Yes, he owns a house in this place. I said, well, this will doesn't dispose of that asset. There's nothing in this language that gives you the house that he actually left. It only gives you a house that was deemed It was sold before he passed away. So here, very counterintuitive.
Right.
I'll be specific, and that'll make it better.
Right.
No. As a matter of fact, wise counsel will help you. For instance, let's say my wife's name was Elizabeth. Okay, that's fictional. But let's say her name was Elizabeth. And I wanted her to have everything. So I'm going to be really diligent. I write down our house, and I start looking around. I write down the cars, and I put down VINs, and I do all that stuff. That will be out of time by the time I sign it. My account balances will have changed. I may or may not still own that car. I may or may not still own that house. I may have changed brokerage firms. All kinds of things are going to change. But the reason it's so hard for me is I was always told in school I should be as specific as I possibly can be so I can get a good grade. And what I really need to do is I really need to have language that says, in my case, since I'm Mr. Bailey, when I die, Mrs. Bailey gets my stuff. What stuff is that? Don't know.
Everything.
Everything. Don't know where I'll live. Don't know what I'll be driving, which is really one of the challenges of it. The other is people want to be specific because they think if it's a one of a kind, it's better. I use this example. I think, not to be controversial, but I think the reputation for Toyota is they make a pretty good automobile. But now I buy the Toyota and I tell you, well, Keith, I bought a new Toyota, 2024. But I went in, of course, I changed the exhaust system and the electronic fuel injection, I did a little adjustment on that. And, it has a certain size tires and wheels, but I changed those. And I'm feeling really good about my new Toyota. And you say, well, Jay, I've never known you to be that mechanical. I've never known you to be much of a wrench. I don't know that you're much of an engineer. Wouldn't you consider that if Toyota has a reputation for making good automobiles, you might not want to change the basic design and structure of what they built? The answer is you're right. I do need to be careful about that. But we run into that all the time where somebody, they had a wonderful thing they'd read sometimes in a novel or in a short story or in Uncle Hank's will from Nevada in 1949. And boy, they really wanted that for their will. But that was ill-advised. That specific language, that favorite language, that romantic language, and that leads into something else. I may be having some really sad feelings about some of my loved ones right now. And so I'm going to just express myself in my will.
Oh boy.
But these feelings change.
Sure.
And they pass. And a good lawyer is going to help you say, let's not do that. The last chapter on the book on Sally, I know Sally is not speaking to you right now, and you guys are not communicating with Sally, but let's not write in a will that may end up memorializing it forever your current feelings for Sally. Mm-hmm. Let's be really careful that we do that in a way that it won't cause, as my friend Keith Spencer has said about family law matters, won't cause any more scar tissue than is absolutely necessary.
A lot of people know, and you and I have talked about this, that in Texas, you can actually write your own will. Mm-hmm. But it is not as easy as people think, and it is so easy to make mistakes. In every area of the law, we practice most of what we do here in Texas in the English language. Yeah. And we all think we have a pretty good handle on the English language. And they start writing a document and they think they know what it means. They certainly know what they intended it to mean.
Yes.
But as in every other field, some of these words are defined terms, meaning that the legislature or whoever wrote this section of the code defined the term to have a specialized meaning. And I use the word consideration as an example for a lot of people. We use the word consideration at the table all day long. We know what the heck it means. But if you're in a contract dispute, the word consideration is a magic word.
Yeah.
And it means something that you would have never thought it meant. I'll give you another example, and that's one of the reasons why you don't want to necessarily try and write your own will, especially if you have a complex estate or you have real estate. I've even seen do-it-yourself forms. I think you and I looked at one time, that you'd fill out the form, you'd print out the paper, you'd fill out the form, and if you had filled it out correctly and put all the pages in the right order, you could thumb the corner of the pages and Willie the Will, a cartoon character, would do a little dance in the corner.
He would.
And you're dealing with, your life's work, your life's estate, and it's really worthy of having someone help you with it. And wills are just not that expensive.
No. Most of us in the state of Texas baseline, the way that they want to scare you into having complex, drafting done is, well, probate's just terrible, right? It's awful. It takes years and it costs tens of thousands of dollars. Well, in Texas, it doesn't. The average case, we try to shoot to take a will. If we've drafted the will, which means it's drafted correctly, we can probably probate the estate. We can get everything done that the law requires, including about 5 minutes in front of a judge, a lot of times on Zoom, within about 90 to 100 days of the time that somebody passes away. And you're probably going to spend, we don't charge on a percentage basis, but most people don't spend 0.5% of the estate. So you're talking about, let's say the average cost, including court costs and filing fees, was $3,000 to probate the estate. Well, most people's house is worth $300,000.
Sure.
The average house in this area is probably $450,000. Okay, so already just to transfer the house to make sure that's worked, you're down to a tiny percentage of it. But more than that, you've named an independent executor. Mm-hmm. So not only does Mrs. Bailey get everything, but Mrs. Bailey's in charge. Murphy's Law applies all the time, but Murphy's Law especially shows up when I'm sick or hurt or somebody dies. Mm-hmm. So about the time I passed away, a check came in the mail that was made out to me. Okay, my wife is my independent executor. She's going to be able to handle that. God forbid I'm killed in a car wreck. There's litigation involved in that. That's okay. She's my independent executor. She can handle that, et cetera, et cetera, et cetera. Mm-hmm. And it morphs, it segues into when we talk about powers of attorney, because we all want to live right up until we die.
Right.
But about 70 or so % of us will not live right up until we die. We will be legally alive, but we, for either a period of time, and that period of time may be right before we pass away, we will not be able to handle our own affairs. Mm-hmm. And so powers of attorney, where Mrs. Bailey can handle things, and Mrs. Bailey can be in the room, and she can be at rehab, and she can be at the follow-up visit, and she can, because I have my car wreck right before the taxes are due, and she'll be mad because I didn't get the taxes filed earlier. She can file for an extension for us. And she can take care of the stuff that needs to be taken care of until I can get better or until I pass away, in which case she's my independent executrix. So two big things about estate planning. One is I have a right to say who gets my stuff. And secondly, I have a right to put the person in charge, the people in charge, because we're always going to build in, we want you wearing a seatbelt with a shoulder harness. We want you to have airbags, suspenders, and belts. We want anti-lock brakes in your car. We want to build this so that, for instance, it would not be unusual if Mrs. Bailey received everything and she was my independent executor, and then If she passed away about the same time I did, or she predeceased me, then maybe our children would serve as beneficiaries and as executors and as the alternates on the powers of attorney. So you build redundancy into it so that you can, among other things, so you don't have to change it too often. We always tell people, hey, this ought to be good for 20 plus years, but the reality is over the course of a couple of decades, you're liable to have death, disability, or divorce that impacts these choices. So don't just put this away forever, thinking that all these people that you named in 1984 are still going to be okay in 2024 to do all this stuff for you.
Well, that kind of goes back to what you were saying before, that it might be better to say, little Susie gets my car, because you may change cars.
Absolutely. Absolutely.
The other thing I would point out, again, if you don't take any of these steps, I don't think most folks realize just how difficult and cumbersome it can be for your heirs. For example, my wife and I had you prepare me a will. Easy will. If I go, she gets it all. If we go together, the kids get it.
Yeah.
Pretty straightforward. And I think at the time we wrote it, my kids were still minors, and so you put in a guardian for them.
And now that's going to apply to grandkids.
Yes. Okay.
Well, the guardianship, and I apologize for interrupting. The guardianship will not apply to my grandkids under most circumstances, but we'll put in most wills, we'll have a testamentary trust, contingent testamentary trust in there. And what it says is, if you haven't had enough birthdays, if you're one of my beneficiaries and you haven't had enough birthdays, you don't get handed your stuff. We have an adult.
There are
look out
fewer
for that
things
stuff.
more dangerous in the world than a 15-year-old with a big check.
Well, and the line is, it makes me cringe, but the line in estate planning is, if you give a young person money, you might as well just give it to their dealer, and you hope that's an automobile dealer. So that's the scary thing about that. But in our wills, where that used to refer to our children, let's say the number was 25.
Okay.
Now it applies to our grandchildren. So now the very people that we were worried about protecting until they got to be 25 or 30, and they're all past that. Now, if my wife and I passed and one of our children passed and their share went to their children, now that still covers, for instance, let's say I had a couple of sons.
Okay.
Uncle so-and-so could be the trustee for nieces and nephews, and Uncle so-and-so could be the trustee for nieces and nephews, just in case my wife and I are both gone and one of the boys predeceases. So you're building multi-generational protection and contingencies in there, partly because we don't like high maintenance. We don't want you to have to change these. We want you to change them in decades, not in months or years. So that's part of why we do it that way.
So let's say that my wife and I don't have a will. We haven't done any of this planning whatsoever. And we're on a vacation and go down in a plane crash. The hoops that our children would have to jump through to be able to pay the mortgage, cash the checks, and take care of the legal obligations are terrible.
And here's the assumption.
I mean, a judge has to get involved then, right?
Oh, my goodness. The public assumes, well, if my wife and I were killed in a plane crash, our kids would automatically... No, they don't automatically anything. Oh. Today, if you want to do business with me, you can do business with me. If I die this evening, you can't do business with me tomorrow. You have to do business with my quote-unquote estate, which, by the way, another term. In Texas, I've shared this with you before, but Texans generally will respond, oh, I don't need any planning. I ain't got nothing.
Okay.
And so what you say is, well, okay, you don't own any real estate. Well, I just got the house. You don't have any cars. Well, yeah, I got the truck. Well, and you start talking them through. But they get this idea that estate planning is for people that own yachts and ranches and property in different, countries.
Right.
The reality is it's much more difficult for a family of medium means to go through this process than it does people that are wealthy.
Mm-hmm.
If you're wealthy and you have to throw, thousands of dollars at this because you didn't plan, then it's thousands of dollars, which represent a small percentage of your estate. If you're of average means, like most of us are, this having to have witnesses and having everybody have to agree and then having to establish an independent administration by statute, case in point, we're tracking down somebody. We've got 3 kiddos. We know where 2 of them are, but one of them has really struggled. And we're not sure we can find him. Well, that's okay if I've got a will, because I didn't name my child that's struggling as my independent executor. I named one of the ones that's not battling mental health issues or addiction or going through post-traumatic stress. Mm-hmm. I don't bless people by assigning them things that are difficult for them. So I've got this oldest child, but I decided I'd go without a will, and I'm sure it'll all just work out. And now we can't find little brother. And this whole thing just craters. We're involved in litigation. We're begging the court to help us move on with this. We're posting bonds and incurring huge fees. And all because instead of taking a couple hours of our time and literally for a couple, you might be able to get all the estate planning you would need for the rest of your life at a price point somewhere around $1,000. So we spent $20,000 trying to patch all this together, mm-hmm. instead of spending $1,000, $500 for each of us approximately, to try to put that together and be prepared. So we do a lot of wills, we do a lot of contingent testamentary trust. Then there's the magic, trust or magic, right? My hair would grow back and it would be dark brown again, and I could still run and jump and sing. And they are very useful. Trust can be extraordinarily useful, and they're very important. They're essential in states where they don't have an independent administration, where they don't have a streamlined probate process. But even in Texas, if you come in and present to me and say, okay, relatively simple estate, we've got a little place in Colorado, we've got a place in Florida, we're going to do a trust. I've been through probate in both Colorado and Florida. We're not going back. Okay? So in a case where you've got, it's still relatively simple, what we're going to do is we're probably going to build a trust, mm-hmm. and it's like an igloo cooler. Picture a receptacle. We're going to put the Colorado property in it. We're going to put the Florida property in it. We're going to put the Texas property in it. Now we're still going to draft a will.
Okay.
And that will's called a pour-over will. And I ask this question to clients: do you know why hotels have toothbrushes? Because people forget their toothbrushes. Okay? So there's the bank account that I forgot to put in the trust. There's the check that's coming on a deal where a guy bought a piece of property from me and I carried a note, but I didn't really want to put the note in the trust, et cetera, et cetera. There's still going to be a pour-over will that catches the stuff that didn't get in my receptacle, my igloo cooler, and pours that into the trust itself. Now, the reason that this is worth it is because we can save many hours and several $1,000s not doing probate in these other states. If, on the other hand, I've got 3 properties in Texas, it's probating a will with 3 residential or small business properties is not much different than probating one where I live in an apartment or where I'm in a condo or whatever else. I use this example. I've represented some Texas lottery winners. Mm-hmm. And I tell people, You can drive from here to Austin with a $20 bill in your pocket, which is usually how I've driven from here to Austin during the course of my life. Or you can drive from here to Austin with a $56 million Texas lottery ticket in your pocket. And I've done that. Same trip. Same number of miles to Austin. Same automobile. Burning the same amount of gas. There's not a lot of difference between the weight of a $56 million lottery ticket and a $20 bill. 20 is a little heavier. But so the bottom line with probate is it's not going to be, oh, mine would be really expensive because I've got these 3 rental houses or something like that. No, that's not going to really add a lot of cost to it. That's going to be pretty straightforward to do it that way. But you really want to sit down with somebody that knows the right questions to ask. Mm-hmm. And as I fire hydrant, as I fire hose your answers, Keith.
Well, the other thing I was thinking about is that if you have minor children heirs, mm-hmm. and you don't have a will, and let's say if Ma and I go, we want Aunt Bessie to take care of the kids.
Yes.
It's not that simple for Aunt Bessie. And without papers that appoint her as the trustee, yes. She's got to get a lawyer. She's got to do annual accounting.
Yes.
And she's got to get approved by the court, and she might not.
Yes.
Because she had that speeding ticket she forgot to show up to court for.
Absolutely.
42 years ago.
Her husband died having battled cancer for years. She had to file for bankruptcy because the expenses of his health care were overwhelming to her. She's a great person, but she is less easily going to be approved by the court based on some financial history or other things. So, very few times do I encourage people to testify from the grave. Usually I'm like, no, let's not. Especially, let's not testify from the grave 30 years before you died. Right? Catching my random thoughts. I love the idea of an opinion budget. I just heard that one. I need to have an opinion budget where I'd say, I'm not an expert on everything. I think I'll just express my opinion somewhat less frequently on certain topics.
Do that.
Well, I think that would probably help us all. But although I usually say don't testify from the grave, appointing a guardian is one of those times when it's essential that you testify from the grave, because you are able to put in front of the court of competent jurisdiction, this is who my wife and I wanted. Mm-hmm. And oftentimes I will have people that I probated a relative's will not terribly long ago, and her youngest child was, I believe, 64.
Okay.
But of course that will had provision for she and her brother, that they had put together when those kids were minors and put that all together. And she said, well, I guess this doesn't apply anymore. And I said, no, it doesn't. But how sweet is it that she at least took the time to designate who she wanted to be y'all's guardians.
Right.
If something had happened to her, 50-something years ago as opposed to last month.
So if someone wants to come see you about their estate planning or perhaps putting together a will or a
Sure.
trust, what kind of documents do they need to gather to come see you?
Generally, all the answers for an initial consultation. A lot of times because of phones, when I ask you to give me the address and the cell phone number of your alternate, power of attorney designee, you're able to say, yes, they've moved, they're at such and such an address, and this is her cell number. But usually and part of the reason that I don't need to know what yesterday's balance is on your Fidelity account is because, one, we're hoping not to transfer your Fidelity account by your will. We're hoping to transfer that Fidelity account outside of probate. Case in point, Mr. Bailey passed away. That was held ideally as joint tenants with right of survivorship with Mrs. Bailey, so that he is not going to have to be involved. She's not going to have to be involved in anything having to do with the probate process.
Mm-hmm.
She's simply going to provide. She's going to continue to use the account. It's going to be her account. She's going to show them a death certificate at some point to tidy up Mr. Bailey's name being on it. But that's the kind of thing where when you come in, you'll say, well, I've got this, and I've got this, and I've got this, and that's great, but I don't need vehicle identification numbers. I don't need your Fidelity or Schwab account number. I don't need that stuff. Here's where I would. It's a winnowing question, okay? I'll say, do you think your estate is worth in excess of, and I'll pick a number, I'll say $5 million. And people will generally say, no. You can actually, if my spouse and I are both citizens of the United States, we can have a huge amount of money and assets and it not have any impact on an estate tax. Okay? We're talking about, for me as an individual, let's be really conservative and say $13 million. Okay? So let's round that way down and say Mr. and Mrs. Bailey could have $25 million worth of assets and the federal estate tax is not going to take a penny. Okay? So we're not usually worried about that. Then I'll talk to you about, do we have any kiddos or grandkids that are receiving help from Medicaid or maybe Social Security disability? That's another winnowing question where I'm trying to figure out, can I really do for you what I think I can do for you? And sometimes during the course of that conversation, it'll come up, no, and then we'll sit down and we'll talk, and they'll say, our middle son's oldest is on the spectrum. I'll say, oh, okay. And we'll have a conversation about that. And they say, he's high functioning and he does well in school and he's a great kid and we're awfully proud of him. But there's a possibility that if we dump cash in his lap when he had his 25th birthday, that might not bless him. Great. Let's talk about how we can avoid that. Let's talk about how we can bless him and not curse him by leaving him some of our assets. So the size of your estate, where your estate is located. Remember my example, if it's in Texas and Florida and Colorado, we've got a different estate plan than if it's in Texas. And then let's talk about the kiddos and the grandkids and the people that are going to be beneficiaries. Right. And if I know the answers to those three questions, I'm well on my way to being able to give you advice about your estate plan.
Okay. We talked about words meaning different things. Everyone has heard, we're signing up for Little League Baseball. We need the signature of a parent or guardian.
Yeah.
Guardian is one of those terms that we all misuse on a daily basis because you almost can't avoid misusing it. Yeah. But a guardianship is a special animal.
It's a very serious matter. It is something that's going to involve doctors and lawyers and judges and has become increasingly specialized. And one of the ways that I want to avoid a guardianship, if I can, is I'm going to have two different types of powers of attorney and an advance directive to physicians that I have executed. Uh-huh. And that's going to significantly lessen the chances that somebody's going to need to try to establish a guardianship for me.
Okay. Well, Jay, is there anything that you want to leave folks with to have a little bit better understanding about the nature of what we've been talking about?
Yeah, I think it's a little bit like going to get your teeth cleaned. Now, there's probably somebody out there that just really loves to get their teeth cleaned. I actually like having clean teeth. I just don't like the process much. I don't like making an appointment. I don't really like going much. But I like it afterwards. But it's a no-brainer. That's a good thing to do.
Sure.
So estate planning is not a whole lot of fun, although most people that I meet with say, oh, that wasn't that bad. And I say, well, no, we don't inoculate you, and you don't have to do feats of strength. We have you slay no dragon. So it's fairly straightforward stuff, but you've got to do it. The fixin'tas will fail miserably. And what you'll do is, if you're not careful, you will leave your family at a time when they're extraordinarily vulnerable and emotional and broken. And if they were 4-cylinder cars, they're running on about 1.5 cylinders. And you'll leave them without having made provision. Doesn't cost a lot of money, doesn't take a lot of time. It's a really good value, and everybody ought to do it. But I also understand, thinking about our mortality and the possibility that we might be diminished or disabled, that's not very much fun.
No.
I'd rather, if I had my druthers, go to a ball game or watch a good film. But it's something that everybody needs to do. And hopefully you'll go to see somebody, and we'd love it if you'd come to see us. We like to help people.
That'll do us for today. I'm Keith Spencer. This is J.C. Bailey, the Vice President of Bailey Galyen. And we hope you come down and see us and ask us some questions and come to the Legal Cafe and have a latte with me. We'll see you next time.